Hi, my name is John Danoon, and I'm the Security Risk and Compliance Program Manager here at UCI, and I'm part of the OIT Security team. And today we'll be talking about security reviews and Appendix DS. So the first question is, why do we have Appendix DS in the first place? And that's really our primary contractual tool to make sure that UC data and systems are kept secure whenever we're sharing information or providing access to third parties. And primarily that is usually cloud services, software as a service out into the cloud, that sort of thing. But it can also apply to any consultants that we might hire, or even service and maintenance contracts of people coming onto campus and performing IT services for us. Appendix DS really applies to all data, not just toxic data. That is a common misunderstanding. We really want any data that we share with a third party to be kept secure. Even something relatively benign like email addresses, we don't want to have those abused. Consider, for example, that we might have a contract with a third party to send out an email announcement to all of our students or something along those lines. We don't want that third party to resell those email addresses to marketers that might impact our students. So we really want all data protected contractually. We want all services that we might engage, anything from free services all the way up to multi-million-dollar purchases, to be covered. And in fact, free services can really be the most dangerous out there, because they also make a lot of their money by reselling information or doing things that UC may not approve of. It's all purchase modes, from PAL cards to purchase orders, so really everything is potentially covered by Appendix DS. One clarification is this does not apply to software that's only installed and used locally. It needs to have some third-party or cloud component to be covered by DS, although this line can be blurry from time to time because some software does have cloud components, but that'll have to be evaluated on a case-by-case basis. But in general, third-party risk is something that is really important to UC, because we have no control of our data once it's been given to a third party, and we really need to have some contractual assurance that that data is going to be kept secure to UC standards. So what are the components of Appendix DS? There are three sections to it. The first is the contract terms, where we have a purpose and introduction, we have a glossary of definitions, and then there are 9 articles that set out the requirements of Appendix DS. There's Exhibit 1, and this needs to be filled out by the unit making the purchase. This is really intended to define what kind of data will be part of this contract, and that's really important to be able to inform the supplier of the type of data that is going to be part of the contract, so they really understand what their requirements are, both from a data and a legal perspective, for protecting this data. And lastly, there's an Exhibit 2, and we'll talk a little bit more about that, but that's the supplier's initial security plan that they returned back to UCI. So Appendix DS requirements in a nutshell. You'll notice that I started the numbering at 3, and that's to correspond with starting with the 3rd article in Appendix DS. But these are the 9 articles that are really basic, straightforward protections that we want to have in the data security appendix. Number 1 is we want the supplier to agree to protect our data and not sell it for other purposes without our permission. That seems pretty basic. Number 4 is they need to have a documented security plan that we can evaluate, and that helps us judge how mature they are at protecting data and whether they have secure processes in place to protect that data. Article 5 talks about having some sort of evidence that they're actually following their own security plan. Typically, this is a third-party assessment or audit, and a SOC 2 type SOC Type 2 report is kind of the gold standard, but there are other documents that we can work with as well. Article 6 is we really want them to tell us when they make changes to their security plan. Most critically is if they do anything to decrease the security that they previously agreed to. And we really want to be able to be aware of that in case we need to change the terms of the contract or renegotiate the contract. Number 7 is when the contract ends, we want them to either return our data to us in some format or destroy it as appropriate and not hang on to it and have our data sitting out there somewhere. Number 8 is we want them to tell us if there are ever any subpoenas or legal requests for our data. They may not always be able to share that information with us, but if they have that ability, we want to know about it. Number 9 is one of the biggest components of Appendix DS, and we really need the supplier to let us know if any of our data has ever been breached. And if it has, let us know. Work with us to find out root cause and what happened and how better to protect it in the future. And we want the supplier to bear any costs, either for notification or other security costs, if it is determined that they are responsible for the data breach. And a data breach is something that's significant enough that we have an out clause in the contract, and we can terminate the contract based on a breach if we so desire. Article 10 is the supplier agrees not to install any backdoors or any other illicit code into our software or systems. And Article 11 is they agree to perform background checks as appropriate on any employee that has access to our data or systems. Exhibit 1 is basically the exhibit that the requesting unit needs to fill out, and it consists of 3 sections. The first is on the protection level, which in turn sets the cyber insurance requirements in the terms and conditions document, so it's really important to have that noted here. Probably won't mean a lot to a supplier because the protection levels are an internal UCI construct, but it's also useful for the security team when we're doing an evaluation to really understand the type of data that's being included in the contract. Section 2 is the data element descriptors, and that basically is a bunch of boxes that help describe what kind of data is this. And we've pre-populated that with a lot of common data types that are used at the university, and we'll talk a little bit more about that in a moment. And then lastly, kind of tied to the types of data in Section 2, Section 3 specifically lists any laws, regulations, or contract requirements that are needed to protect that data. And that's really important to tell a supplier so they really know what their responsibilities are if they accept this data and work with us on this contract. And it also helps determine from a UCI security standpoint how we evaluate the compliance of this contract and the security maturity of the supplier, because we have some flexibility in the depth of analysis that we do when we look at a security plan. And if the data is low risk, we might have a lighter touch when we do a security analysis on the security plan, whereas if there are some really high security requirements like PCI or HIPAA, we're going to have to really look in detail and have a strict interpretation of a lot of the requirements. So protection levels in Exhibit 1. So if you have any questions about what that means, there are a couple of URLs here at the bottom. The first one is a UCI site where we talk about all the protection levels and what they are. The second URL is a similar information at UCOP. So refer to those guidance if you need to have more information on protection levels. Protection level 1 is basically low-level public information, and all the way up to protection level 4, which is really toxic, regulated information like social security numbers or credit card numbers, medical information, that sort of thing. If you need some help trying to determine protection level, we have a classification decision tree available from the UCI site that kind of walks you through a bunch of questions to help you determine what possible protection level your data might have. And then even though it's listed as optional on the Exhibit 1, please provide a short description on what your data is and how it's used. And that helps not only the supplier, but also the security team better understand what kind of data is involved in this potential contract. So section 2 of Exhibit 1 lists a whole bunch of different types of data here. It's kind of daunting to look at this list. It's alphabetized, but quite honestly, many of these really aren't used that often. So I'm going to go through some of the common ones in a little more detail here. The first ones are the personally identifiable information. This is going to be part of almost every contract, because there's just a lot of PII in a lot of the data that we share with third parties. It can be anywhere from P1 to P4. It's a very broad legal definition, so it is basically anything that is individually associated with a person. And it can include the really toxic elements like social security numbers and credit card numbers as well. There's also HIPAA records. These are very specific things related to healthcare, and it needs to come basically from a covered entity like a hospital or medical center or a business associate that they do business with. That is contrasted a little bit with general health data, which is everything else. It can be very similar information, but since it's not tied to a covered entity hospital care environment, it really is a separate classification. We want to protect both, but HIPAA is really the most important to protect because there are significant penalties if that data is compromised. And specifically with HIPAA, we will need a business associates agreement if we enter into a HIPAA agreement with any third party. We're a university, so we have a lot of student data, and we want to have that as a checkbox as well, whether or not it is FERPA or not, and we'll talk a little bit more about that in a moment. Payment card data is the credit card processing or credit card payment environment. This area is really tightly regulated and applies to any credit card processing, whether UCI is doing it or whether the third party is doing it. So we really need to be aware if any of that is coming into scope of the agreement. GDPR is basically protecting PII of European residents, and there are two major categories of that data, from just the general personal data elements. And there's an item called special data, which really gets into some very specific fields that are considered particularly toxic in GDPR. And you would also need the GDPR appendix if you are sharing any of this data with a third party. The rest of the items are research data elements. So you really need to work with your faculty members because they will be aware if any of their research or data is covered by any of these entities. Definitely work with faculty members because they are going to be the ones who know if any of these data is present. Exhibit 3 is the contracts and regulations that apply to the data types that we just described. And again, there are a couple different sections here. There's a privacy set of laws and regulations and a security set of laws and regulations. And some of these will apply in different cases or not. So the common laws and regulations that we deal with, number 1 is the California Information Practices Act. And this has been around since 1977, and there's a constitutional requirement in California that the state is required to protect any data that it collects about individuals, and that includes UC since we're a government entity. So it has a lot of requirements for how personal information is collected and managed. And it was recently updated in 2003 to include requirements for notification if certain data elements are breached. So this really is the bread and butter of pretty much any data that we collect and share. So this box will almost always be checked on anything that we share with a third party. There's also the Consumer Privacy Act, which is a relatively new item. UC is not directly beholden to that, but suppliers that we do business with may be required to follow CCPA, so you might need to inform them of that. FERPA is, again, the the federal regulation that surrounds student records, and it only technically applies to data that's considered officially part of the student record. We still want to protect student data as much as possible, but FERPA only applies to official student records. And interestingly, if their students go to the student health center, their medical information is covered under FERPA instead of HIPAA, so just be aware of that. The European GDPR, we've talked about that in a little bit, but that's the general regulation to protect European resident information. And again, the GDPR appendix is required for that. HIPAA High Tech is the PHI that we talked about with the HIPAA security rules. One of the things that makes this different is it really needs to have a review by the UC Health people. So campus security is not really aware of some of the ins and outs of HIPAA, so that really needs to be reviewed by UC Health at the moment. The California Confidentiality of Medical Information Act is basically the California version of HIPAA, so those will almost always be checked together. I'll skip over the substance abuse one since that's kind of a marginal one, but the payment card industry is, again, all of the credit card processing. So if anything is being done with credit cards, this box needs to be checked. And Gramm-Leach-Bliley is basically protecting the privacy of student financial aid information. And at some point, that also may be subject to the NIST 800-171 requirements, which is any data that we get from the federal government. There are a bunch of other regulations in that section as well, and most of these will correspond to the similar data types, like in the research areas for the DARs and DFARS and things like that. So work with your faculty members to determine if any of that data is present and any of these regulations apply. So part of our challenge with Appendix DS is negotiating terms can be lengthy. Large companies, the Googles, Microsofts of the world, simply won't negotiate Appendix DS. They have their own terms and agreements, and they're big enough that they can tell us to take it or leave it. So often large companies won't negotiate at all. Smaller suppliers, especially smaller value contracts, they don't want to negotiate either. It's just not economically worth it to them to negotiate a complex requirement for a few $1,000s. Also, be wary of suppliers who accept terms too quickly, because sometimes I've found with suppliers, they just want to get the business and they'll sign any piece of paper and really don't understand the requirements of Appendix DS and what they really need to do to protect our data. We also see wide levels of security maturity amongst suppliers. So many smaller or mid-sized companies just simply don't have formal security plans that they can give us, and almost certainly don't have their security plans audited to the standard that we want to see. So it's been pretty challenging to actually try to get good information from some of these companies. There's a tool called the HECVAT, which can sometimes help close the gap if they don't have a security plan, but we try to get as much information to be able to make a good judgment on what kind of security terms the supplier may have. When we do a risk assessment, as we mentioned earlier, the depth of that assessment really will depend on the protection levels and the laws and regulations that apply to the data, how complete a supplier security plan is, how their audit looks like, what the HECVAT looks like, and if there are any significant gaps, either in the security plan or with Appendix DS. We need to go through a security exception process to make sure the unit is really aware of these gaps and can accept risk or find another supplier that has better security terms. We're really trying to improve the Appendix DS process. We're finding that one size really doesn't fit all very well. It's a single document, and it really is pretty heavy in the negotiation process. So we're trying to find ways where to accommodate smaller suppliers that don't have, good security plans, don't maybe do background checks, may not have the levels of cyber insurance that we're looking for, and really take a look and see if we can come up with some way to assess those groups a little better, especially in low risk cases. So what we're looking at for future plans is we're trying to develop an Appendix DS Lite for low risk use cases with fewer and more simplified questions. We want to develop some risk treatment plans, so if a supplier doesn't have a security plan, they can fill out a risk treatment plan and we can get an idea of what their security maturity is. We also want to delegate some authority to the campus UISL, so we'll be providing some training and we'll encourage them to do some of the low risk assessments in the units so they don't have to bubble up to security and potentially be part of that. And then we're also looking at purchasing a governance risk and compliance tool, a GRC tool, to help streamline supplier risk assessments and have better documentation. I'll just finalize here with this chart of improving Appendix DS. So we're trying to find good ways of communicating to the campus as far as what contracts may be exempt, what may be a light review, what requires a full review, and then the most toxic areas like HIPAA or PCI that might have additional requirements beyond Appendix DS. And that's all I have. Thank you.